There's a lot of people in prison right now on he said, she said sexual assault cases where there's no physical evidence. I'm Adam Rossen from the Rossen Law Firm, and in today's video, we are going to be exposing and debunking 5 common myths about sex crimes. I'm a former prosecutor and owner of the Rossen Law Firm. We are expert criminal defense attorneys in South Florida that handle sex crimes. The first common myth about sex crimes is that hiring a lawyer makes you look guilty. And let me tell you, that couldn't be further from the truth, okay? First of all, police officers are not necessarily there to help you. They're not. They're there to close a case. As sad as it sounds, they're really not even there for the truth most of the time. They're just there to get a case, move it along, get it off their desk. And a lot of times they get it off their desk by making an arrest. So real police officers, they know the game. They know when you hire expert representation, it's a good thing. Real police officers actually prefer it because then there's a dialogue between the parties. And I can tell you, when police officers get arrested, investigated, or charge themselves, well, what do? They hire lawyers. It's not about the appearance of, oh, what's a police officer gonna think? They're gonna think I'm guilty. Because you know why? Once the allegation has already got to them, they already think you're guilty. That's the way that they're trained. That could not be further from the truth. It is a terrible misconception. Lawyers can help you. They can steer the right direction. And actually, police officers appreciate it because then they're going lawyer to police officer instead of police officer direct to the client or the accused. And hiring a sexual assault defense attorney is not an admission of guilt. The second common misconception is that if the victim recants, the entire case is just automatically over. And that's not the way it works. Now, when those things happen, it helps the case. A lot of times it helps the case tremendously. But the prosecutors take these charges very seriously, and it's the state of Florida, especially when we're in Florida, against the accused. It's not the alleged victim versus the accused. So that's something that everybody needs to really know and understand. And a lot of times the prosecutors don't believe an alleged victim when they recant. They believe the alleged victim. They believe what he or she originally said. And then they think that the recantation is because of something else. And prosecutors often will continue to try to prosecute cases. Maybe there was a third party that witnessed it. Maybe the alleged victim spoke to a third party afterward. Maybe there's physical evidence. Prosecutors don't like dropping cases, especially of this nature, just because an alleged victim changes his or her story. So that is a very common myth, and everybody needs to understand. Well, what does that mean? Because it does make it easier to get the case dismissed. It makes it easier to push forward, but it's not automatic. So your attorney still needs to push hard, pressure the prosecutors, negotiate with them, and really hold their feet to the fire, because it's not just going to be a snap your fingers, voila, case over automatically. It's not as easy or as simple as that. So the third common myth we're going to talk about is that there must be physical evidence in order to get a conviction. So these sex crimes cases, they can go a few different ways. A lot of them have physical evidence, but even a bigger majority don't. And the cases that don't have physical evidence, for example, maybe semen or blood or other evidence, it's usually just a he said, she said. And one of the myths is, oh, well, if it's a he said, she said, then it's simple. It's easy. Again, snap your fingers, the case will go away. There's no possible way a jury can convict. And that's not entirely true. He said, she said cases with no physical evidence are, generally speaking, easier than when you have mountains of DNA evidence and mountains of blood evidence or other types of physical evidence. Yes. But there's a lot of people in prison right now on he said, she said sexual assault cases where there's no physical evidence. So what do I mean by this, right? Just because it's easier doesn't mean it's guaranteed. And that's the whole point. You still need an amazing team of attorneys. You still need to have those attorneys do the work, take the depositions, file the motions, grill these accusers, come up with a defense, especially when we're talking truth is on your side, because there are truly innocent people in prison on these type of cases. He said, she said, sexual assault, rape, sexual battery, with no physical evidence. We've seen it time and time and time again. And like anything, the attorneys that you hire make all the difference in the world. So the fourth common myth that we're going to debunk is that you cannot plea bargain a sex crime. Any type of crime, including murder, are always open to plea bargains, negotiations, everything. We've had many, many, many cases where they start off with a 25-year mandatory minimum on a sex crime, a 15-year mandatory minimum, looking at, much larger prison time. And before you know it, we've made calculated decisions and strategy. And as we've defended the case, we can end up plea bargaining down to a misdemeanor, down to a lower felony that's not a sex crime felony, that won't put people with sex offender probation or be on the registry. All types of crimes can be plea bargained. Most of the time, it's in the client's best interest, because a lot of these cases, if we're going to be able to negotiate and plea bargain down from major prison time down to probation and a lesser felony, well, it means that the prosecution's case is falling apart. But then again, it also means that the prosecutors are willing to give a reduced charge. But if you go to trial and you gamble wrong, and the jury still convicts, well, then that could backfire. So there's a lot of things that go into this, and it's not a quick 5-minute or even 30-minute discussion between attorney and client. These are part of discussions that need to happen over a series of months as the case is progressing along. That is a common myth, and that is absolutely not true. You can plea bargain and negotiate any type of criminal case. And the fifth and final myth that we're going to debunk today is that any general criminal defense lawyer can handle sex crimes. Absolutely not. Sex crimes are a huge specialty area of criminal defense. And like anything, especially when we're talking about people's lives, their future, and their freedom, and as serious and complicated these are, you need real sex crimes experts. Attorneys that know about DNA, that know about blood, that know about rape kits, that know about Williams rule evidence and controlled calls and all the different things that we talk in our videos that, of course, we will link up to this video. Defending a sex crime is vastly different than defending a drug crime, vastly different than defending a financial crime, and completely different than defending a DUI. Hopefully you're never in this position, right? A lot of people think, well, just anybody will do. And when the stakes are so high, 10, 25, 40 years in prison, even an accusation, and especially even a conviction to probation, can ruin people's lives forever when they become on the sex crimes registry. It ruins careers. These cases are very complex, and you need people that have studied it and handled dozens, if not hundreds, of these cases before. So that is the fifth and final myth that we're going to talk about today that we have now debunked. I hope this information has helped you. If you need anything at all whatsoever, you can always call us at the Rossen Law Firm, 754-206-6200.